Good day, and welcome to Epstein, Becker, and Green's Non-Compete and Trade Secret Developments and Trends, a year in review and looking forward webinar. Before we begin today's presentation, please be informed that today's webinar is being recorded and that participant phone lines will be placed on mute throughout the program. You are welcome to submit questions throughout the program by using the Q&A feature provided by WebEx. And at the end of the program, with time permitting, the speakers will address your questions. You are also welcome to submit questions directly to the presenters following the webinar, and contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein, Becker, and Green will communicate the availability of the webinar recording and access to the PowerPoint materials. We are pleased to have fantastic speakers today. And at this time, I'd like to turn the webinar over to David Clark.
Thank you, and welcome everyone to our webinar. I am David Clark, joined by my colleagues Aime Dempsey and Will Cook. We are all resident in Epstein, Becker, and Green's New York City office, and we work in the firm's litigation and labor and employment practices. Today, we're going to take a look back at what we saw in the world of trade secrets, non-competes, and other restrictive covenants, both in 2018 and so far here in early 2019. We'll discuss recent notable cases and try to provide some insights into the latest developments and expected trends in the evolving legal landscape of trade secrets and employee mobility issues. Here are the topics we're planning to cover today. First, we're going to take a deep dive on what was the most significant piece of legislation enacted in 2018 in this area, the Massachusetts Non-Competition Agreement Act. Second, we'll look at what some other state legislatures have been up to in terms of potential and actual new laws regarding non-competition agreements and other restrictive covenants. As you'll see, this remains a hot topic around the country. Third, because not all the action on these issues has taken place in the states, Aime will discuss what's been going on at the federal level in terms of non-compete reform. Fourth, Will is going to give us a rundown of some of the most significant restrictive covenant case law decisions from 2018. Next, we'll turn to some recent developments in trade secret protection, including another new Massachusetts law and a significant New York State case. And for number 6 on our list here, Amy's going to discuss the continued scrutiny that's being focused by prosecutors and other government officials on agreements among competitors not to poach one another's employees. And in conclusion, we'll leave you all with some practical advice. So let's jump right in. For a lot of practitioners in this area, including me, a highlight of the year 2018 was Massachusetts finally passing legislation limiting the use of non-competes. Massachusetts has long considered itself a rival to California in terms of the tech businesses that are located in Massachusetts, and a debate has gone on for years there as to whether the Commonwealth should seek to emulate California's near total ban on non-competes. In theory, to promote freer movement of labor and more startups and more successful tech companies and other businesses. So over the past few years in Massachusetts, multiple bills regarding non-competes were introduced in the state legislature. Legislators and attorneys have debated whether it's better to promote greater employee mobility in terms of limiting non-competes, or to allow employers more latitude to contract with employees to limit their post-employment actions in order to protect the employer's trade secrets and confidential information. So the new statute strikes something of a compromise, so let's look at it. First, the basics. The new statute's requirements pretty much apply only to non-competition agreements. And it only applies to them, to those that are entered on or after October 1st, 2018. So that means confidentiality provisions and non-solicitation provisions, either of clients or employees, are not really affected by the new statute. Employers are free to have their employees in Massachusetts enter into those sorts of agreements as they always have. So what are the key new requirements of the new law? First, the employee or candidate for employment must be provided with the non-compete agreement at least 10 days in advance of being asked to sign it, and must be advised that he or she has the right to consult counsel in reviewing it. Second, any new non-compete signed in Massachusetts will only be enforced if it's a year or less in duration. Third, a non-compete must now be supported by payment to the employee during the non-compete period. How much? The statute says it must be either A, garden leave pay of at least 50% of the employee's highest annualized base salary within the 2 years preceding the employee's termination, or B, other mutually agreed upon consideration between the employer and employee, provided that such consideration is specified. Fourth, non-compete must be of limited geographic scope. The law sets a presumption that areas where the employee provided services or had a material presence or influence during the last 2 years of employment are reasonable. And then last, a similar presumption of reason is set for the scope of prohibited activities that's specified in the agreement. The new law also makes any non-competes entered after October 1st, 2018 in Massachusetts unenforceable against certain classes of employees. And those classes are folks who are non-exempt under the Fair Labor Standards Act, undergraduate or graduate student interns, employees terminated without cause, and employees age 18 or younger. To make clear its limited applicability, the new Massachusetts statute sets forth 10 types of restrictive covenants that are not subject to its requirements. And those 10 types are shown on this slide and include non-solicits of employees and clients, sale of business agreements, forfeiture for competition clauses, confidentiality agreements, and severance agreements. As with almost any new statute, some questions remain. So here's a few that we see, which will probably be litigated and eventually decided in the courts in the coming years. For one, the statute definitely states that it does not apply to provisions restricting solicitation of the employer's clients, i.e. its existing clients. But the statute really, on a close reading, is silent as to whether it limits solicitation of the employer's prospective clients. I think it does. I think that was the intent. I don't think a non-solicit clause of relating to prospective clients needs to be supported by garden leave pay and all the other bells and whistles that the new statute requires, but it's a little unclear under the statute, so we'll see. Another question is, as I said, the new non-competes entered into in Massachusetts must be supported by consideration, either garden leave payments during the non-compete period or, as the statute says, other mutually agreed upon consideration. But what does that mean? Well, it's unclear. We foresee potential disputes over whether the parties mutually agreed upon consideration for the non-compete will be found to be sufficient if it's later challenged. A third question is what compensation will be required if the employer waives some or all of the non-compete period. Imagine an employee has left her employment and is 3 months into honoring her 6 months post-employment non-compete, but the employer then decides to release her from the remaining 3 months. Would the employer still be on the hook to pay her the remaining 3 months compensation that their agreement and the statute seem to require? I don't know, but we'll have to find out in some judicial decisions, I expect, in the future. And lastly, how will a termination without cause be viewed and interpreted under the new law. Time will tell on all of these issues, but there's plenty of fodder for the courts to consider. All right, so that's Massachusetts, just one state. Let's look at some others, and here's Will Cook.
Good afternoon. So many would argue that those states and their courts that enforce broad non-compete provisions and employment agreements hinder economic growth in those states. And this argument has gained traction in the last 2 years following President Obama's October 2016 call to action to state legislators for state non-compete reform, which Amy Dempsey will discuss in a few minutes. Several states in just the last year have sought to pass legislation placing restrictions on the use of non-competes, given this new environment in which we're in. First, I'll discuss Utah. So Utah's Post-Employment Restrictions Act was adopted in 2016, providing that for a post-employment restrictive covenant entered into on or after May 10th of 2016, an employer and an employee may not enter into a post-employment restrictive covenant for a period of more than 1 year from the date on which the employee is no longer employed by the employer. In March 2018, Utah expanded non-compete protections to workers in the broadcasting industry, covering television, cable, and radio broadcasters to address the alleged abuse of non-compete agreements in the broadcasting industry in Utah. A non-compete between a broadcasting company and a broadcasting employee is not valid in Utah unless the employee is paid at least $913 a week, thus barring non-compete contracts for employees earning less than approximately $47,500 a year. The non-compete must also be in a written employment contract with a term of no more than 4 years, and the employee is terminated, and if it will not be enforced unless the employee is terminated for cause or breaches the employment contract. Additionally, the duration of the non-compete cannot be longer than the earlier of 1 year after the employee's termination date or the expiration of the original term of the employment contract containing the restrictive covenant. Non-competes that do not comply with the statute are void in Utah. Turning to Idaho. At approximately the same time that Utah amended its non-compete statute to protect workers in the broadcasting industry, Idaho amended its own non-compete statute in response to arguments that its budding tech sector in and around Boise was being harmed by its so-called pro-employer statute. Turning back to 2016, Idaho amended its non-compete statute entitled Restriction of Direct Competition, Rebuttable Presumptions, to make it easier for companies to restrict the movement of key employees and key independent contractors. That new subpart 6 of the statute provided that if a court found that a key employee or key independent contractor breached a non-compete agreement, a rebuttable presumption of irreparable harm was established, and the burden of overcoming that presumption shifted to the former employee to show that he or she had no ability to adversely affect the employer's legitimate business interests. In essence, it required the employee to prove a negative. So, reaction to the amendment was very negative, and because Boise, Idaho, is trying to establish itself as a tech hub, and Idaho is trying to make itself more attractive to tech companies and their employees, similar to Silicon Valley, California, the 2016 amendment was eliminated in the 2018 legislation. Additionally, the burden has switched from the employee to the employer, who must now show the employee's departure adversely affected the employer's legitimate business interests. Turning to Colorado. Colorado's non-compete statute, entitled Unlawful to Intimidate Worker, Agreement Not to Compete, codified at Colorado Revised Statutes, Section 8-2-113, was enacted in 1982, and the first time it was amended was in April 2018, which I'll discuss in just a moment. The statute provides, in relevant part, any covenant not to compete which restricts the right of any person to receive compensation for performance of skilled or unskilled labor for any employer shall be void, with certain exceptions. But this subsection shall not apply to any contract for the purchase and sale of a business or the assets of a business, any contract for the protection of trade secrets, and executive and management personnel and officers and employees who constitute professional staff to executive and management personnel, among others. And notably, since 1982, pursuant to the statute, covenants not to compete could not restrict the right of a physician to practice medicine. However, contractual provisions making doctors liable for damages if they compete and take patients are enforceable. Now, the 2018 amendment clarifies that physicians may disclose their continuing practice and provide new contact information to any of their patients who have a rare disorder without liability for damages to their former employers. The goal of the amendment is to avoid interruptions to the continued care of individuals with rare disorders. Interestingly, pursuant to the statute, the rare disorders must be recognized by the National Organization for Rare Disorders, Inc., or otherwise known as NORD, N-O-R-D, and their web address is rarediseases.org. According to NORD, more than 1,200 diseases are considered rare in the United States. Among them, acute respiratory distress syndrome, several types of anemia, Bell's palsy, botulism, cerebral palsy, cystic fibrosis, Graves' disease, Hodgkin's disease, meningitis, rabies, sickle cell disease, spina bifida, Tourette syndrome, and yellow fever. It seems that there are a lot of very common, what would be considered uncommon diseases on this list. Next slide. Over the last year, there have also been a variety of proposed and unfortunately rejected legislation, depending on how you feel. So pending presently in New Jersey since May 10th, 2018, is a bill that seeks to provide stricter requirements for the enforcement of restrictive covenants. If enacted, the legislation would significantly curb the use of non-competes in New Jersey. It would permit employers to enter into non-competes with employees as a condition of employment or within a severance agreement, but they would only be enforceable if they meet all of the requirements set forth in the legislation. Some of these requirements are if the non-compete is entered into in connection with the commencement of employment, the employer must disclose the terms in writing to the prospective employee by the earlier of a formal offer of employment or 30 business days before the commencement of the employee's employment. If the non-compete is entered into after commencement of employment, the employer must provide the agreement to the employee at least 30 business days before the agreement is to be effective. The non-compete shall not be broader than necessary to protect the legitimate business interests of the employer, including the employer's trade secrets or other confidential information, such as sales information, business plans, and customer or pricing information. The time period of the non-compete must not exceed 1 year following the date of termination of employment. And the non-compete shall not restrict the employee from providing a service to a customer of the employer if the employee does not initiate or solicit customer. And unless the employee is terminated for misconduct, the employee must be paid 100% of their pay during the non-compete period if the employer enforces the non-compete. So this has been sitting for quite a while. We speculate that it could be dying in committee or perhaps already has died, or the legislature is studying and watching what other states are doing, particularly because a new governor, Democrat Phil Murphy, started his term in January 2018, shortly before the legislation was introduced. It's also not uncommon in New Jersey, based on our experience, for bills to sit for several months before they're brought back up, and Governor Murphy has a reputation for being pro-employee. So we'll see what happens in the next month or two, if anything. Next, in Vermont introduced a bill that would essentially limit or prohibit agreements that prohibit individuals from competing with their former employers following the conclusion of their employment with just very limited exceptions. For example, the sale of the business or the dissolution of a partnership agreement. Now, bills that have been rejected include in Pennsylvania, where we learned it was just recently died in committee, and there that agreement was also extremely broad in dealing with non-compete. As well as Washington, we understand that that died because there were concerns among Republican legislators with the income threshold, and as well as New Hampshire, where it sought to prohibit, New Hampshire sought to prohibit non-compete for low-wage employees, generally for employees making approximately $15 an hour. And so that wraps up the part of this presentation concerning statutory developments. And Amy will now, I'll turn it over to Amy now.
Thank you, Will. Just to talk for a few minutes about what's going on at the federal level. As Will mentioned, for the last really about 3 years or so, the federal government has kind of expressed an interest in non-compete agreements and how their prevalence may be affecting the economy, particularly employee mobility and employee compensation, especially for the lowest wage earners. So Congress and some of the federal agencies have done some investigating and made some attempts, so far unsuccessful, at reform on the federal level. And as Will mentioned, which I'll get to in a little detail in a minute, the Obama administration in the spring of 2016 offered some ideas or guidance for reform on the state level, which, as he explained, doesn't seem to have been taken up very effectively so far. But going back to 2015, the 114th Congress had a bill introduced by Senator Chris Murphy of Connecticut, co-sponsored by Al Franken of Minnesota, called the Mobility and Opportunity for Vulnerable Employees, or MOVE Act. That was structured to prohibit non-compete agreements between employers and low-wage earners, defined as those who earned less than $15 per hour or the minimum wage in that employee's area, or earned less than $31,200 per year. It would have also required that employers post notice of the prohibition and let others know of their non-compete before they let the employees know of their non-compete intentions before the employees were hired. One of the themes that runs through some of the federal concern is that employers are including non-compete agreements and clauses without regard necessarily, in some cases, to their enforceability, perhaps in the hope that an employee will not try to get it overturned and will just abide by it without realizing that it's not enforceable. And the government has, you know, at the state and federal level, has expressed some concern. So a lot of these initiatives include notice provisions. From the perspective of the Obama administration, as the economy emerged from what they call the Great Recession, and a bunch of new jobs were created, there was still some concern about some of the economic trends and challenges that seem to remain. So the president asked agencies to look into some of the trends and causes of some of these issues, and one of the things they looked into were non-compete agreements. In March of 2016, the United States Department of the Treasury Office of Economic Policy issued a report called Non-Compete Contracts, Economic Effects and Policy Implications, and the White House followed up with its own report in May of 2016. They noted that while non-compete agreements can protect innovation and business and encourage investment in training, they can also have negative effects, especially if they are overused. Some of the negative effects that the administration noted are restriction of bargaining power, a constriction of the labor pool for other companies if one company ties up some of the good employees, potentially creating unemployment if an employee abides by a non-compete that requires them not to work and they can't, locate work outside of the restrictions of the non-compete. Potentially depressing, non-competes in theory could depress economic growth in a particular region by limiting the diffusion of workers in the workforce. In other words, they're not sort of mixing it up enough and therefore not the particular area is not growing as well as it should, and even restrict consumer choice. So the White House came out with best practice policy objectives. The theory was that if some of these objectives are followed, overuse and misuse of restrictive covenants might be limited. The sort of areas that the White House, based on the Treasury Department's report, sees as a need for reform are in terms of the categories of workers that are affected by non-competes. Overall, the Treasury report found that research shows that about 18% of American workers are subject to non-compete agreements, and that a certain percent, maybe 15% or so, of low-wage workers or those without college degrees are also subject to non-compete agreements, which goes against the idea that such agreements are in place to protect trade secrets. The Treasury report found that perhaps trade secrets protection would occur at least more frequently in the higher wage or more professional types of jobs, but there are plenty of low-wage workers that are covered by non-compete agreements, and this is cause for concern. In addition, those employed in public health and safety positions often are covered by non-competes, and the concern there is that, that there should be free movement among them to ensure the highest level of employment in those positions. And then, those who are laid off or terminated for cause should not perhaps be limited in going to their next position. There's also a concern that those who sign non-competes don't know about them ahead of time and don't possess trade secrets, so that there's a low value to the employer for having these non-compete agreements, and at the same time having a high cost for the employee. In other words, if the non-competes aren't protecting trade secrets, they might not be benefiting the employer as much as they're hurting potentially the employee, and the balance that non-compete seek to strike might be out of whack. Another area that the Treasury Department is concerned with is the transparency and fairness of non-competes. A lot of employees are not even aware that they have signed a non-compete while they're employed. Some of them don't read their agreements, and the non-competes are included in them. Other cases, the employees agree to accept a position, thereby rejecting other potential positions that they might have been offered. And then when they're coming on board after having rejected these other positions and narrowing their choices, they're presented with a non-compete agreement and feel that they don't have much choice. And another issue, as I mentioned earlier, is that non-competes are being included in circumstances in which they are not enforceable, and employees, unaware that they're not enforceable, are abiding by them anyway. To that point, research has suggested that up to 22% of employees in California report having a non-compete agreement in their employment contract, and as we know, those are not enforceable in California in general. To have such a high percentage of employees saying that they have agreements included suggests that some employers at least are relying on the chilling effect of an employee rather than the actual enforceability of the agreement. And similarly, the notion is that some employers may be drafting agreements that they know to be overbroad and not enforceable, or maybe they're unaware, and that employees follow them without being aware that the restriction is too broad. So among the suggestions for states are to ban non-competes for certain categories of workers, to improve the transparency and fairness of non-competes, perhaps through notice for sure, and perhaps even consideration separate from the status of employment for non-competes, working on the timing of execution, in other words, advising employees ahead of time before they accept an offer that a non-compete may be required, and encouraging employers to draft enforceable agreements. One of the things that the White House report looked at in some detail is the various ways that states have of looking at the enforceability of non-competes. And the report was particularly interested in the few states that have adopted what they call the red pencil doctrine. In other words, if a state uses a red pencil doctrine, which apparently includes Virginia and Nebraska, if any provisions are unenforceable, the non-compete is void and not enforced. The White House report felt that if more states were to adopt the red pencil doctrine, employers would be discouraged from including provisions that they know aren't enforceable, such as an over length of time, an over breadth of region, an over breadth of competitors that the restrictions apply to, and would pay more attention to the enforceability of each provision, whereas many states use a blue pencil approach, and employers may feel, well, I'm just going to include all of these overbroad provisions or not worry about it, because if one provision is unenforceable, the court will just fix it for me, and those who care to abide by the broader provisions, I'm even more protected. So another effort by Congress to address non-compete reform was the Workplace Mobility Act. We talked about the report from the Obama administration and the Department of Treasury there, but the current administration is at least to some extent, and current Congress continuing efforts to take a close look at non-compete agreements. In April 2018, Senators Murphy, Warren, and Wyden introduced a bill that would have prohibited the use of non-compete agreements entirely, really, although still allowing employers to protect their trade secrets. The idea is that workers would be able to pursue new jobs and higher wages without fearing legal action. And the notification of employees that we talked about a few minutes ago would have been required, and that they would have been required to be informed that such agreements are illegal. Would have allowed enforcement by the U.S. Department of Labor and a private right of action as well. There was a companion or complementary House bill also. Both of them seem to have died in committee. Then last fall, FTC Commissioner Rohit Chopra issued a report indicating that perhaps if Congress can't do anything, the Federal Trade Commission should write rules defining when non-compete agreements for employees are permissible. He made a case for how the FTC is better suited, perhaps, to enhance competition and to get into the details of it, and went into Chevron and other authority to make the case that the FTC would have the authority to issue such a rulemaking even if legislation is too slow. And we haven't given up yet. The current Congress has a bill now in committee, introduced 2 weeks ago on January 15th by Senator Rubio of Florida. His bill would be called the Freedom to Compete Act. It would focus more on the lower wage agreements, that lower wage employees, by prohibiting agreements between employers and most non-exempt employees, restricting post-employment work. So it would be a modification to the 1938 FLSA addressing the non-exempt workers there. The bill has been referred to the Committee on Health, Education, Labor, and Pensions. No indication that anything has happened with it yet. Of course, there was a partial shutdown for most of that time. But so far, it does not appear that there are any co-sponsors or any equivalent bill in the House. One of the things about this Freedom to Compete Act is it defines some of the restrictions as applying to any work. So an employee would not be restricted from taking on any work that competes, and therefore could be read very broadly if, in fact, it goes anywhere. So that's kind of the update on what the federal government has been up to or thinking about, and I'll turn it back to Will for recent restrictive covenant decisions.
Thank you, Amy. So courts across the country continue to closely scrutinize non-compete provisions to ensure that they are not overly broad. And first, we'll discuss a case from Wisconsin. In January 2018, the Wisconsin Supreme Court dealt with the issue of whether a non-solicitation of employees provision, sometimes referred to as an NSE, violated the state's non-compete statute. The facts there were that the Manitowoc Company manufactures, among other things, construction cranes. Manitowoc's chief engineer, John Lanning, who worked at Manitowoc for over 25 years, resigned in 2010 to join a direct competitor, Sani America, and also in its crane division. Lanning then communicated with at least 9 Manitowoc employees about potential employment opportunities at Sani, taking some of them out to lunch and showing them, around the area. Thereafter, Manitowoc filed suit alleging wrongful solicitation of former co-workers in violation of a 2-year non-solicitation of employees provision that Lanning had signed in 2008. Significantly, the NSE prohibited Lanning from soliciting every one of Manitowoc's 13,000 worldwide employees without any limitations based upon the nature of the employee's position or Lanning's personal familiarity with the employee. Lanning argued that the NSE provision is a restraint of trade governed by Wisconsin's non-compete statute, section 103.465, which we'll refer to as the non-compete statute. Even though the statute explicitly refers to a covenant not to compete and does not mention anything about non-solicitation. As the statute provides that any covenant described in this subsection imposing an unreasonable restraint is illegal, void, and unenforceable, even as to any part of the covenant or performance that would be a reasonable restraint. The court conceded that the NSE did not conform to textbook examples of a covenant not to compete, but stated that the explicit purpose of the statute is to invalidate covenants that impose unreasonable restraints on employees. Manitowoc finally argued that the real purpose of the NSE was to prevent Lanning from raiding its employees if he were to leave and join a competitor. He had been there for many years, knew about many employees, even if he didn't actually know them individually. The lower court granted Manitowoc's motion for summary judgment in its favor, which was reversed by the Intermediate Appellate Court, the Court of Appeals, which held that the NSE violated the non-compete statute. So the issue can be framed as, are non-poach or anti-raiding clauses covered by Wisconsin's non-compete statute? which requires that restrictions be reasonably necessary for the protection of the employer. The Wisconsin Supreme Court said yes, the NSA provision was unenforceable. Wisconsin's non-compete statute broadly applies to restrictions on competition, including post-employment restrictions on the ability to solicit former coworkers. The court stated it would be an exercise in semantics to overlook the statute merely because a provision of the agreement is not labeled a covenant not to compete. The statute has been applied to agreements viewed as restraints of trade. The NSC provision was overbroad, and Manitowoc does not have a protectable interest justifying the restriction imposed on the activity of the employee. We'll turn to Arkansas. In March 2018, the Court of Appeals of Arkansas ruled on the issue of whether a one-year prospective injunction seeking to enforce an expired non-compete agreement was appropriate. And the fact there, in 2013, employee Mike Neal of HVAC vendor Bud Anderson Heating and Cooling, which I'll refer to as BAHC, signed a non-compete agreement restricting him from competing in 4 counties in Arkansas for 12 months after the termination of his employment with BAHC. In 2016, Neal resigned to join a competitor of BAHC located within BAHC's territory and subsequently solicited a BAHC customer to be serviced by Neal's new employer. BAHC then sought a one-year prospective injunction seeking to enforce the expired non-compete agreement, which the lower court denied, so BAHC appealed. Neal argued that BAHC's appeal was moot because the injunction sought was beyond the 1 year from the date of termination period. So the issue there was framed, can courts extend non-compete restrictions beyond the expiration of the contractual non-compete period? And the Arkansas Appellate Court said yes, extension of a non-competition period is within a court's broad, equitable powers. Moreover, the court specifically rejected Neal's mootness argument by relying on an exception to the mootness doctrine, and that is capable of repetition yet evading review. And we'll next move to the Northern District of Illinois. Janitor problem sinks Illinois non-compete. In April 2018, Judge Ellis of the Northern District of Illinois addressed the enforceability of a restrictive covenant which prohibited the employment of an employee in any capacity at another company in the entire industry in which he worked. Dumroff was the former employee, began working at a pharmaceutical and medical device company, Medex, in Arizona on March 7, 2011 as Director of Business Operations, and at that time entered into a non-compete agreement. In January 2012, he was promoted to the position of West Coast Regional Director, and in January 2013, he became a director of one of Medex's subsidiaries. Within that period, and in consideration of his continued employment with Medex, Dumroff executed another non-compete agreement, which provided, in essence, that he was prohibited from being connected in any manner with any business that offered products or services in competition with Medex or engaged directly or indirectly in the business of Medex within a 50-mile radius of any office in which he worked for Medex. In August 2017, Dumroff resigned to take a position with a competitor of Medex, ProLink, based in Cincinnati. In that position, 90% of his work would be based in Ohio and Kentucky, but he conceded he'd continue to work occasionally in ProLink's Arizona office, which was located near Medex's Arizona office, in fact in the same county. On a motion to dismiss pursuant to Rule 12b-6, the district court invalidated the restrictive covenant because it prohibited defendant's employment in any capacity at another company in the same business. The defendant argued that the restrictive covenant would bar him from even working as a janitor at another company. The court noted that restrictive covenants are disfavored in Illinois, and the proponent of the restriction must show that its full extent is necessary to protect its interests. This particular non-compete prevented the employee from working for a competitor in a non-competitive capacity, and there was no factual scenario under which it would be reasonable. The takeaway here is that employers should make sure their non-competes are drafted as narrowly as possible to meet their needs, and not be so broad as to even bar an employee from working as a janitor for one of their competitors. We'll next move to the Ninth Circuit. Golden v. California Emergency Physicians Medical Group. In July 2018, the Ninth Circuit addressed whether a no future employment clause violated Section 16600 of the California Business and Professions Code. And the facts there: the California Emergency Physicians Medical Group, we'll refer to as CEP, fired Dr. Golden in 2007 because he lacked board certification. The doctor then sued CEP for various causes of action, including alleged employment discrimination based on race. After reaching an oral settlement agreement in open court, the doctor had second thoughts and refused to sign a written settlement agreement that included a provision prohibiting him from working not only for the former employer, but also at any facility CEP may own or with which it may contract in the future. The district court ordered the doctor to sign the settlement agreement, so he appealed. And the issue there, did the no future employment clause violate California's Section 16600, which invalidates every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind, with certain exceptions that aren't applicable here? Ninth Circuit said yes, in part. So the majority noted that the restrictive covenant would affect not only Dr. Golden's employment at CEP itself, but also his existing and future employment at third-party facilities where CEP provided services, even if the CEP services began after the commencement of Dr. Golden's employment, and even if the CEP services did not compete with the services Dr. Golden provided. The prohibition on future employment at facilities owned or managed by the former employer did not impose a substantial restraint and was therefore acceptable. However, a prohibition on employment with third parties who contracted with the former employer was overbroad because it was a substantial restraint on a lawful practice of medicine. Because California courts apply Section 16600 strictly, the Ninth Circuit nevertheless found the entire settlement agreement void and unenforceable, threw it out, and sent it back to the district court. We'll now turn to the California Appellate Court. AMN Healthcare versus Aya Healthcare Services. In November 2018, the Court of Appeal of California, the 4th Appellate District, addressed whether prohibitions on employee solicitations are permissible under Section 16600. Just stepping back, it has long been settled that non-compete provisions in California are invalid under Section 16600, which invalidate every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind, as I noted previously. Now, in the California Supreme Court's 2008 decision in Edwards v. Arthur Anderson, the court left open whether employee non-solicit provisions were enforceable. In fact, in 1985, the Court of Appeal for the 6th District in Laurel Corporation versus Moyes adopted a rule of reasonableness standard in reviewing non-solicitation provisions. However, in AMN Healthcare, the Court of Appeal ruled that a broadly worded contractual clause that prohibited solicitation of employees for 1 year was void under Section 16600. And the facts there, AMN and Aya are competing healthcare staffing companies that provide travel nurses to medical care facilities throughout the country. The individual defendants were former travel nurse recruiters of AMN who left AMN and joined Aya, where they also worked as travel nurse recruiters. The individual defendants signed non-disclosure agreements with AMN containing a 1-year NSE provision, a non-solicitation of employees provision. And after the individual defendants resigned, AMN sued them for, among other things, violating the 1-year NSE. Defendants filed a cross-complaint requesting the court to declare the NSE void and enjoining AMN from enforcing the provision against other former AMN employees. The trial court entered judgment in favor of defendants and entered an injunction against AMN. The issue there, did the non-solicitation clause violate California Business and Professions Code, section 16600, which invalidates, again, every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind? And the California Appellate Court, 4th District, said yes. This prohibition was void under section 16600. It restrained the individual defendants from practicing their chosen profession, which was soliciting and recruiting travel nurses. The court also affirmed the injunction which prevented AMN from enforcing any contract in California purporting to restrain its former employees from soliciting any employee of AMN to leave the service of AMN. So, California courts consistently hold that Section 16600 expresses a settled legislative policy in favor of open competition and employee mobility, and that the interests of employee mobility are paramount to the competitive business interests of employees where no illegal conduct has occurred. So although the AMN Healthcare Court took into account defendants' profession as recruiters in making its ruling, the court also broadly questioned the continuing viability of Laurel's use of a reasonableness standard in evaluating the enforceability of non-solicitation provisions in light of Edwards, the California Supreme Court's 2008 decision. So the court then held that whether or not the reasonableness standard of Laurel was expressly rejected, the non-solicit provision in that case was still unlawful. The court reasoned that the facts of Laurel were distinguishable because it dealt with a few key senior executives. However, following this decision, unless and until California decides to review this matter, employees who are accused of breaching a non-solicitation agreement will now assert AMN to claim that such agreements violate Section 16600. And finally, the Illinois consideration issue. I'll just briefly address this, given the time. So in Fifield, in 2013, the Illinois Appellate Court held that absent other considerations, there must be 2 or more years of employment after signing a restrictive covenant for there to be adequate consideration. And since that decision, Illinois state and federal courts split on whether to follow Fifield, and they remain split. In fact, just in mid-2018, in Industrial Packaging Supplies versus Channel, the court stated, "My prediction is that the Illinois Supreme Court would reject a bright-line 2-year rule in favor of a fact-specific approach." And just in the prior year, in the state court decision, Automated Industrial Machine versus Christophilus, the court stated, "We acknowledge that there is a possibility that our Supreme Court will reject a 2-year bright-line rule in favor of a more specific rule." It should be noted there, the appeal to the Illinois Supreme Court was denied. Until the Illinois Supreme Court weighs in, employers will provide consideration in addition, or should provide consideration in addition to mere continued employment. And I'll now turn it to David Clark.
All right, thanks, Will. Just one thing before we leave the world of restrictive covenants. We did get one question typed in to us, and that question is basically, how do you know what law governs a restrictive covenant? For example, if a company is based in New York with no office in New Jersey, but has a few employees that work from home in New Jersey, what law applies to a contract that they might have with the employer, like a non-compete or a non-solicit? I would say the default rule is that the law of the state where the employee is located would govern. However, many times in the contract, there will be a choice of law specified, and it's often the law of the state where the employer is located. So in our example here, it would be New York law designated in the contract as applying, but it doesn't have to be that state's law. They might designate California, or probably not, but Florida, some other state's law. And this question, choice of law, can often lead to a fight in court, and very often, the judge has to decide what law is going to be applied to a restrictive covenant. I'll move on to trade secrets now in the interest of time. I think there's another question maybe coming in, but just to keep things rolling here. Developments in trade secrets. As in the restrictive covenant realm, one of the biggest legislative events in 2018 in the trade secrets world was the enactment of a new statute in Massachusetts, which became the 49th state to enact some version of the Uniform Trade Secrets Act, or UTSA. New York is now the only state out of the 50 that has not adopted the UTSA in some form. So just in case you're wondering what is the Uniform Trade Secrets Act generally, it's a model statute that provides a private right of action for holders of trade secrets to sue and recover damages against persons who misappropriate those trade secrets. It provides legal definitions of words like trade secret and misappropriation, which essentially means acquiring and sometimes disclosing something by improper means, which is another term defined under the Act. The goal of the UTSA is to provide basic ground rules and legal standards for evaluating and dealing with claims of trade secret theft. So the Massachusetts UTSA was passed in the same legislation as the Massachusetts Non-Competition Agreement Act, which I talked about before. Like that law, the UTSA in Massachusetts became effective on October 1st, 2018, and it does not apply retroactively. So next slide. What are some significant features of the Massachusetts UTSA? One big change in Massachusetts new law is that it protects trade secrets that offer actual or potential economic advantage to their owners. The prior state law in Massachusetts protected trade secrets that were in continuous use within a business, but potential economic value of a trade secret was unlikely to warrant protection. Now, possibly, that can be protected. Another significant change is that the new Massachusetts law now allows courts to enjoin actual or threatened misappropriation of trade secrets. So it allows an employer, rather than having to wait for its trade secrets to be stolen and or disclosed before they can act, it allows an employer who has a legitimate basis for fearing that kind of thing happening to seek an injunction in court against a former employee against that threatened misappropriation. It's not all good news for the employers under the Massachusetts UTSA. An employer's claims of trade secret violations must be made upon an adequate basis. If there really is no adequate basis for a claim of trade secret misappropriation asserted by an employer, then the new law eases the burden on the defendant employee or former employee who seeks to recover his or her costs and attorney's fees if they've been victimized by a claim of trade secret misappropriation brought in bad faith by the employer. Finally, many of you may remember that in 2016, the U.S. Congress enacted the Federal Defend Trade Secrets Act. An employer victimized by an employee's trade secret misappropriation may bring claims under both its state's Uniform Trade Secrets Act and the Defend Trade Secrets Act, the federal statute. There are at least a couple of important differences between the federal act and the Massachusetts UTSA. First, if you're an employer who has had its trade secrets stolen, the federal act may afford you an avenue to make an ex parte application to a judge to seize materials from the person who has stolen them. The Massachusetts UTSA does not allow for that. Second, the federal act contains a section concerning employees who disclose a trade secret of the employer while in the process of reporting or investigating a suspected violation of law. The federal act affords employees immunity from a claim that they violated the federal act asserted by the employer relating to such a disclosure, which might otherwise be in violation of the employee's confidentiality agreement or other obligations. And the Massachusetts UTSA does not have a similar immunity provision. So while we're on the topic of the Defend Trade Secrets Act, Federal Act, what's been going on since it was enacted in 2016? Well, the number of trade secret complaints filed in state and federal courts has increased. They're up over 30% since 2016. And remember, the Defend Trade Secrets Act allows for original federal question jurisdiction in the federal courts for any and all claims asserted under its provisions. That did not exist before, and most trade secret misappropriation claims were heard in state courts. Those that found their way into federal court had to do so usually based on diversity jurisdiction, that is, based on, only in situations where the parties were citizens of different states or countries and had a certain amount in controversy. So many more trade secret misappropriation claims have been filed in federal courts in recent years, including 2018, although the deluge of such complaints that many predicted when the statute was enacted in 2016 has not really materialized. A landmark case of sorts under the Defend Trade Secrets Act was handed down in 2018 in the U.S. District Court for the Eastern District of Pennsylvania. In Christian v. Lannet Company, for the first time, a whistleblower was granted protection under the immunity provision of the Defend Trade Secrets Act. The plaintiff in the case was a manager terminated by Lannet, and she asserted various discrimination claims. Lannet Company asserted a number of counterclaims, one of which was for a violation of the Defend Trade Secrets Act by her disclosure of the company's trade secrets to her attorney. Ms. Christian argued that she was a whistleblower entitled to immunity from such claims, and the court agreed that she had disclosed trade secrets in confidence to an attorney solely for the purpose of reporting or investigating a suspected violation of law. So therefore, she was immune from a Defend Trade Secrets Act claim. Here's something else of note. In the trade secrets area, on November 1st, 2018, the U.S. Attorney General, Jeff Sessions, announced that the United States Department of Justice has ordered the creation of a China initiative to combat economic espionage perpetrated by Chinese actors. This initiative will be led by an Assistant Attorney General as well as a senior FBI executive, 5 United States attorneys, and several other Department of Justice leaders and officials. The goals of the China initiative will be to identify trade secret theft cases, provide adequate resources to investigate those cases, and work to resolve them in a timely manner. Another component of the China initiative is that the Department of Justice will develop an enforcement strategy concerning people such as researchers in labs at universities or workers in the defense industrial base who are or might be co-opted by Chinese agents or individuals or companies into transferring trade secrets to China in contravention of the interests of the United States. The initiative also seeks to identify opportunities to better address supply chain threats, especially ones impacting the telecommunications sector. Finally, on trade secrets, another interesting development in 2018 occurred in a New York State case law decision. In E.J. Brooks Company versus Cambridge Security Seals, the Court of Appeals of New York narrowed the scope of permissible damage claims that plaintiffs can assert in trade secret actions under New York law. The ruling denies plaintiffs the ability to recover costs that defendants avoided through misappropriating trade secrets. This is known as the avoided costs theory, and under an avoided costs calculation, the plaintiff estimates damages based on the amount that the defendant saved in research and development costs by unlawfully acquiring the plaintiff's trade secrets. This decision makes New York law less attractive to certain types of trade secret actions due to this conservative approach in calculating damages. So the takeaway here is that employers should pay special attention to choice of law and choice of forum provisions in their contractual dealings with employees and contractors, as these may have an impact on the type of calculations that can be used to assess trade secret misappropriation damages down the road. So, as with the restrictive covenants, lots going on with trade secret protection in the last year or so. And maybe we'll now switch gears again back to Aime Dempsey.
Thanks, David. One of the things that's a little bit different, we've been talking about non-compete agreements between employers and employees. Another area that's been getting some scrutiny the last couple of years and within the last year is no-poach agreements between employers. The United States Department of Justice Antitrust Division and the Federal Trade Commission are jointly responsible for enforcing antitrust laws. And they've made it clear that, it's always been the case that antitrust laws apply to competition among firms for hiring employees. They jointly issued, therefore, a guidance in October of 2016 that continues to be followed. The Department of Justice Antitrust Division and the FTC want to make it clear, or made it clear, that agreement among competing employers to limit or fix the terms of employment may violate antitrust laws if the agreement constrains the individual firm decision-making with respect to wages, salaries, benefits, terms of employment, job opportunities, that kind of thing. So one of the keys here is that that it's not just firms that are in competition with each other for customers or with respect to products, but if they're in competition with each other for the employees, they are prohibited from entering any agreements that limit their own decision-making on hiring particular employees. The guidance of October 2016 also notes that human resource professionals are often in the best position to ensure that company practices comply with the antitrust laws by doing things like implementing safeguards to prevent inappropriate discussions or agreements. Accordingly, the DOJ and FTC announced that they not only will bring civil enforcement actions against violations of the antitrust provisions in terms of hiring employees, but they will proceed criminally against both companies and individuals, which can include individual human resource professionals, and that those actions taken potentially on behalf of or by the DOJ would not limit the private right of action that an employee or other injured party may have against companies that violate the antitrust laws. And those private rights of action can seek treble damages. So what you need to do is avoid entering any agreements with any other companies that restrict the terms of employment with any firms that compete for employees. It doesn't matter whether such agreements would be formal, informal, written, unwritten, spoken, unspoken. You just can't agree with your competitors for employees on the terms and conditions of hiring employees. The possible consequences are, next slide, are criminal prosecution, as I mentioned, by the DOJ against the employee, the individual employee, or both. Civil enforcement actions. Of course, actions by state attorneys general can proceed against those who violate state law, and civil lawsuits can also proceed. So one way to look at it is that there are various red flags that the guidance has mentioned that may bring the activities of competing firms to the attention of the antitrust enforcement. So do not agree with another company about employee salaries or other forms of compensation, either at a specific level or within a range. So you can't say to your, friend at another employer, let's just make sure that, we keep salaries below X. You can't agree with another company to refuse or to solicit or hire the other company's employees. None of this, you stay off of my employees, I'll stay off of yours. That's unlawful. Don't agree with another company about even employee benefits or other terms and conditions of employment. Even things like one company saying to another, geez, I can't afford to offer gym memberships anymore. How about you? Will you, stop offering gym memberships so my employees don't all quit and run to you? Can't do it. Even expressing to another company, even at a meeting, that the company should not be too aggressive to try to hire each other's employees. Saying things like, we know we can't agree not to poach each other's employees, but let's just not, go too hard against each other's employees, or against each other. Even exchanging company-specific information. So even if you're explaining what your salary range is to a potential competitor for employees could be a red flag. Discussing any of those topics at all with colleagues at other companies, even in social settings, or even being present at meetings where such topics are discussed, can be a problem for the individual employee who has responsibility for hiring, such as an HR professional. And even receiving documents or information from another company about the terms and conditions of their compensation can be a red flag. Now, of course, next slide, the red flags are not exhaustive. There are other things that the DOJ or FTC could consider problematic. And on the flip side, just because, one of these things happens doesn't mean that there's a violation of the antitrust laws. But those are things that you need to be really careful of that you might not otherwise realize. Several enforcement actions have been brought. Perhaps most recently, in April of 2018, the Department of Justice settled a civil suit it had previously brought against a couple of rail companies who had engaged really in naked, no poaching agreements for some years. They basically, at high executive level, decided not to hire each other's employees. What it appears is that it was somewhat informal for a while, and then by about 2011 or so, senior executives agreed just not to hire each other's employees. This was in the manufacture of train and vehicle equipment market. Considered blatant violation that essentially allocated skilled employees in that area to the between the different employers. And the DOJ developed a complaint and settled before filing the complaint, which includes things like both defendants have to appoint an antitrust compliance officer. They have to prepare a plan of compliance. They have to, again, with the notification, notify employees that there was this settlement of a judgment, notify recruiters that they're not entitled to limit the hiring of each other's employees. And it also includes a fairly invasive scrutiny plan by the DOJ. In other words, the government can, upon request, according to the settlement agreement, access each defendant's office to get copies of books and records, to ask for written reports, to do any number of things that ensure compliance by these two individual companies. They certainly, with such a naked violation of the no poaching laws, considered proceeding criminally against the both companies, but they decided that because the guidance really announced the intent to proceed criminally was in October of 2016, the investigation of Norbrems AG and Westinghouse Air Brake Technology Corp. Began before the guidance was issued, and in fact, the defendants both stopped their no poaching agreement before the guidance was issued. The DOJ determined that it was not a case that would be fair to proceed criminally. But those kinds of things, they will not hesitate to bring criminal charges in the future. So where are we? There are a few things that we can, call to your attention as a little bit of practical tips. Certainly, you want to first carefully analyze what your company or what you need in terms of a non-compete type of a framework or limitations protecting your trade secrets. Evaluate any non-compete agreements to make sure that their duration and scope are narrowly tailored to protect only legitimate business interests. And consider relying on non-solicit and confidential information limitation clauses instead of actual non-competes. And consider adopting garden leave rather than a non-compete approach. As David mentioned, you want to pay attention to choice of law and choice of forum provisions to make sure that, if you're trying to protect your non-compete, or if you think that you may have damages against another company, that you have the choice of law that works best for your company. Then with respect to confidential information, it's very important, according to the DTLA and other provisions, to establish and follow procedures to protect confidential information. You have to be able to show that you're protecting your trade secrets and other confidential information in order to enforce it under most of these provisions. And if there is a breach, investigate it thoroughly and immediately. Finally, avoid those no-poach agreements. Don't talk with your competitors about the employee compensation, terms and conditions of employment, and certainly don't agree not to hire each other's employees. I think we have a couple of questions, do we?
Yeah.
Somebody asked, what's the state of enforcement of non-compete in New York, I believe?
Yes.
And New York will enforce non-compete agreements that are narrowly tailored, that are tailored in scope and duration to the legitimate business interests of the employer. A legitimate business interest is not to prevent your employees from resigning. A legitimate business interest may be the protection of trade secrets. It may be the protection of client interests, those kinds of things. And New York, we talked a little bit about red pencil. New York is a blue pencil state. That means that if a part of the non-compete provision that is challenged is unenforceable, but part of it's enforceable, the court may, many judges at least, may agree to reform the unenforceable part to be more reasonable. Yeah? with a couple of other questions that we will, having completely run out of time, answer. We can answer in writing, right, Sylvia?
Yes.
Yes. Thank you, everybody, for joining us, and thank you to our wonderful speakers. This concludes today's webinar. If we didn't get a chance to get to your questions, we will email you. And again, please reach out to our speakers directly if you have questions. And in approximately 2 to 3 business days following the webinar, Epstein, Becker, and Green will communicate the availability of the webinar recording and access to PowerPoint materials. Thank you and have a great day.